Thank you, Deputy Speaker. I rise to oppose the Safety, Rehabilitation and Compensation Legislation Amendment Bill 2014. The bill before the chamber is a direct hit against the workplace health and safety of Australian workers. It takes away the rights of Australian workers to fair and reasonable cover when they suffer the misfortune of an accident at work. And I'm going to come to the legislation in detail, but I want to tell the story through the prism of my brothers. I have five brothers, or six. One's passed away, but five brothers. Two of them who are basically clerks, and three that work in the building and mining industries. Because the history of this legislation, the Comcare legislation, basically was legislation directed to looking after clerks, not the clerks before the table here, but clerks generally, people not in high-risk industries. So two of my brothers, if this legislation was agreed to and they were then taken into such a scheme, it would be appropriate, an appropriate scheme for them. But my three other brothers, who work in the building industry and the mining and construction industries, it would not be appropriate for them. My oldest brother works in the construction and mining industry and provides advice on occupational health and safety. Then the next brother works in the labour hire industry, both supplying workers to the construction industry specifically, but especially, but also the mining industry. And then my other brother, Tim, is a labourer in the construction industry, and I mentioned Tim particularly because it's his birthday today, and I just wanted to send a happy birthday to him. And that is a good thing. I'm sure he's out celebrating with his family now, and that is a good thing. But I want to take the Parliament back to an incident that happened for my brother Tim at the Gold Coast, right almost literally on the border between New South Wales and Queensland on November the 29th, so a few days after his birthday, November the 29th, 1996, when there was a big construction project at Twin Town Services Club at Tweed Heads. And if you know that facility, it's right very close to the border of Queensland. But it was over in New South Wales that the accident happened, where a huge tower crane that my brother was a part of working on crumpled under the weight of a large cement container, or the kibble, which was overloaded, and then a ton of concrete collapsed right beside my brother. He was standing on the platform, and it killed two people, and I'll name those work colleagues of my brother: Rodney Taylor Marsack, 37, a Brisbane dogman, and Wayne Master, 34, a Pottsville concrete worker. And my brother was standing right beside them, and he was hit by the kibble, but wasn't killed, as his two colleagues were right beside him. Now, it took him years and years and years to get over that, not only the physical injuries associated with that accident, but also the mental anguish that comes with seeing your workmates killed right beside you. And then actually my other older brother came along to that construction site because he worked for Lindor's Crane and Rigging, the crane hire company. They were actually working for Leighton contractors on that building project. So I want to tell the story of this legislation through the prism of my five brothers, particularly that brother Tim, who experienced that horrific accident way back in 1996. Thankfully, he's still around to celebrate his birthday, unlike the two gentlemen that died alongside him, Rodney and Wayne. And I say a special hello to their families, and I'm sure that they are still missed. And I know that at Twin Towns there is a marker acknowledging their death. But this legislation, the Safety, Rehabilitation and Compensation legislation, basically has been considered by this parliament and many state parliaments because it has implications for workers in states as well. On the 15th of May 2014, the Senate Selection of Bills Committee recommended that the provisions of the bill be referred to the Senate Education and Employment Legislation Committee for inquiry and a report by the 8th of July 2014. So the bill before the chamber tonight is comprised of 5 schedules. And I'm not going to go in detail to every schedule, but I'll just give a quick run through of the 5 schedules. Schedule 1 extends the criteria applying to a corporation which is seeking a self-insurer licence. The amendments enable those corporations which are currently required to meet workers' compensation obligations under two or more workers' compensation laws of a state or territory to apply to the Safety, Rehabilitation and Compensation Commissioner to join the Comcare scheme. That's particularly of note for companies that operate over the border. And I go back to that initial example I gave of the Twin Towns job site, right on the border. The accident occurred literally 10 metres over the border from Queensland, but that crane company, even though it was a Queensland-based crane company, actually coming from my hometown of St George, the article, the coroner's court that dealt with it, the courts that dealt with it, were all in New South Wales because it was just over the border. I think at one stage the crane was actually in Queensland and its load was actually in New South Wales. So that's the examples that we're talking about how easy it is for corporations to go across the borders. And we see from the deaths, one Queensland worker, one New South Wales worker. So I can understand why corporations would want to come into a simplified scheme rather than deal with two different jurisdictions. The joys of federation. I understand that we're trying to get rid of costs wherever we can, but we also need to look after the people who will be affected by those decisions. Schedule 2 of the bill enables the Commission, the Safety, Rehabilitation and Compensation Commission, to grant group licences to related corporations and makes consequential changes to extend the coverage provisions of the Work Health and Safety Act to those corporations that obtain a licence to self-insure under the SRC Act. Schedule 3 excludes access to workers' compensation where a person engages in serious and willful misconduct, even if the injury results in death or serious and permanent impairment. Schedule 4 excludes access to workers' compensation where injuries occur during recess breaks away from an employer's premises. And I should stress that that is not the case in most state-based schemes. Schedule 5 contains minor technical corrections to the Workplace Health and Safety Act. So there is no requirement that an employer have a minimum number of employees in a particular Australian jurisdiction in order to qualify for a self-insurer licence. So in the example I gave, if it was a bricklayer or something who might have 2 employees, one based in Queensland, one based in New South Wales, they could actually apply to be a part of this scheme. Obviously, it could be a completely different entity that has thousands and thousands of employees scattered all around Australia, and they can see the benefits in having one scheme. But we have to remember with scale, it could be a very, very small entity that's trying to extract maximum advantage and put their employees at a disadvantage. In particular, group licences could be granted to small employers which are not equipped to administer a self-insurance scheme, and that would be my big concern, and one of obviously the union movement's big concern, and obviously every state government and territory government that's interested in making sure their citizens have the best possible scheme. It is clear that Comcare is not adequately equipped to monitor performance or hold self-insurers to account on a national scale if a self-insurer does not meet injury management and return to work obligations. Because who would have thought, but every now and then employers are prepared to lie, especially in some trades where people go out of business regularly, and that unfortunately is the reality of the construction industry. So people are prepared to lie, and if government or the regulator is not prepared to go and look at the books and make sure that best practice is occurring at building sites, construction sites, or even normal workplaces, then unfortunately employers that are prepared to lie will exploit their employees and leave them hanging in the loop. There are also privacy concerns relating to the administrator of workers' compensation by self-insurers. The Comcare scheme was established to cover workers who undertake low-risk work in the Australian public service. As I gave in that example at the start, my 2 brothers that are basically clerks. This scheme was not designed to cover other types of work such as construction, manufacturing or mining, where there is a very, very real risk that you might end up dead at the end of your day at work. They are high-risk industries. A lot has been done to make them safer. However, they are still nowhere near as safe as sitting at a desk and doing a clerk job, with respect to my colleagues in front of me. but you know what I mean. A paper cut's not quite the same as a wall falling on top of you, or a kibble collapsing right alongside you and a crane collapsing. Comcare performs at a lower level than many state and territory workers' compensation schemes because there are no statutory processing times. In particular, there are no timeframes on employer obligations to make medical and other compensation payments when a worker is injured, and often that makes all the difference. If someone can have the right rehabilitation and right treatment, they can go back to work, particularly when they work, when they don't have big leave schemes, sick leave schemes, or the like to cover them during a bad time. The scheme before the Chamber offers lesser benefits than many state and territory workers' compensation schemes, has limited access to the common law compensation, and the amount payable in that case is capped at only $110,000. And this is a concern that's been raised with me, certainly in Queensland. Personally, I believe that Queensland has the best scheme possible. It's been administered under Labor governments and Liberal governments, and it's a good scheme run by professionals and provides we should not be going to this lesser scheme. With all respect to those people covered by the Commonwealth scheme, Queensland has set the standards and we should be maintaining that current process. And I take that interjection from the member for Griffith because I know she worked in this area as a lawyer and saw the horrors that can be visited on workers if they are not treated appropriately. Decisions which are the subject of appeal to the choice of workers' compensation is made by the employer based on financial savings, and employees are not consulted about what this means to them if they are injured. And as I know from my time working for unions, if you don't look after the employee, you can create extra heartache and also mean you've got a less productive employee. So this bill did not form any part of the coalition government's election policy. Therefore, there is no mandate at all for this bill. It's not like those gold promises like no cuts to education, no new taxes, no cuts to health, no cuts to the ABC and SBS, those things that are sacrosanct for those opposite. This was not mentioned during the election at all. It's not in the glossy brochure with the ministers on the front page, the real promises, I think it was called, or the real solutions. That's right. I mean, I've never seen a bigger misnomer, but nevertheless, it wasn't mentioned at all. This bill has no sound policy justification whatsoever. In fact, it undermines all the existing workers' compensation schemes in Australia, including Victoria that under Kennett had moved towards the Commonwealth scheme. This is an ill-conceived bill that ignores the founding principle of Australian workers' compensation schemes and why they were established in the first place. It is more about ideology rather than producing something productive for workplaces. It's the Liberal government once again looking to aid small savings for big companies while injured workers and their families will bear inestimable financial and emotional costs and hardship by being excluded from workers' compensation schemes, particularly as the pension age goes up to 70, and in these industries like construction and mining where it's so much harder for people to be able to do their job right up until 70. Different if you're sitting in an office desk or perhaps a teacher or the like. For example, the bill proposes the reintroduction of an exclusion from eligibility for compensation during recess breaks, which could be as simple as leaving the work site to go and get some food, because often these construction sites can be in an area where there is no food at all. Many workers use breaks to complete employer business and to carry out extra duties. So this amendment would assist unethical employers to avoid their responsibilities. If not for their employment, the worker would not be taking the break in that location and would not be exposed to the risk. There would be no organised sports events and other team-building activities because workers would not be covered if they were injured during these activities. In 1985, the Commonwealth Government legislated for the formation of the National Occupational Health and Safety Commission, which has gone on to do great work. So the history behind this legislation should be looked at by those opposite. I especially say as a Queenslander that this legislation does not apply. Queensland has set the standards in terms of looking after workers when they are injured. We're doing it at a low cost compared to other states and territories, a low cost to employers, and we are able to cover a range of workers in a range of activities. The Comcare scheme that is being proposed would allow for unethical employers to do the wrong thing by their employees, And as I said through the example I gave at the start, this is a scheme designed for workers in safe environments, not those risky environments.
Order. The question is